just said that voters already have said no to slots at the tracks. Refresh our memory. When did that?
2006, Learn and Earn. The Learn and Earn campaign involved slot machines at the racetracks. 2006.
You've got a legislation passed by a Republican General Assembly and a Republican governor, and you're putting it through the courts of Parliament in a Republican-dominated Ohio Supreme Court. How much success do you think you're going to have?
Well, it's all about accountability, and where does authority come from, and do they have the authority to do what they're doing? And according to the law, we believe no, and we've made a very strong case that outlines that. So we have full confidence in the courts that they'll take a look at it and see our case on its merits, and we have a very strong case. We're very confident.
Is the original jurisdiction for challenging that in the Supreme Court, is that no longer?
Well, the original jurisdiction, they tried to do that, but there was a case not long ago where the Supreme Court said the legislature can't tell them what role they're going to play. We're not going to go that way. So that has been decided. Yeah, I believe roughly 6 weeks ago. So that's why we didn't go to the Supreme Court. The Supreme Court had recently said, don't come to us first. We're not a trial court.
As a matter of process, though, that is one of our claims.
You filed that today?
Yes, it's been filed this morning. As a matter of process, the jurisdiction issue is one of our claims because of the statute change in House Bill 1 in 2009 set up the Supreme Court only on 3770.03 and 3770.21. Those two statutes that were in the budget bill were identified by reference to be a part of the original jurisdiction issue and statement in the law. So we have to include that for the court to rule on those two statutes specifically.
I know this isn't a legal argument, but for those on the other side who say, look, now that the voters have said yes to these full-scale casinos, they'd probably be voting yes on the slots at the track. Just let us move ahead.
That's a pretty big assumption to make according to the Constitution. If that was the case, they would put in the language of the Constitution that we could go forward and go wherever we want, whenever we want. And that's the one thing that's very important to remember. Penn and Rock's lawyers wrote this amendment. So if they're not happy with the fact they didn't exempt themselves from the commercial activities tax, which is another point of the litigation, and a strong point of the litigation, if they're not happy that they didn't exempt themselves, they have nowhere to look but in the mirror. They spelled out everything in that amendment, from land plots to specific locations to, when gambling's permitted to take place. Why didn't they put that in there? I mean, that's on them. They wrote the language, and now they're not happy with it, and the governor felt he had to cut a backroom deal to appease them.
Practically, what are you seeking? Like an injunction or?
The Constitution to be upheld, the way voters approved the amendment in 2009. No, we didn't talk about it until the backroom deal was cut. That's what we want. We want the language to be upheld the way it was approved. Ohioans spoke in 2009. November of 2009, they approved the gambling amendment. How they did it, we all know it was low voter turnout. They spent a lot of money, but that's beside the fact.
I mean, I guess just they've been passing rules. They're gonna, the lottery and the racing commission are starting to. They've started the process.
Well, they've started the process, and that'll be a role of the court. And Tom can speak to that if you'd like. We can have Tom speak with you about that. But I mean, that'll be a part of the process. If they get too far down the road, and the court realizes how strong our case is and how valid our claims are, I mean, they're the ones we feel that are in violation of the law. So they're the ones that need to be aware of the situation.
And if I may add to that, if I were to put myself in the shoes of someone who was intending to pursue a video lottery license, I would hold back if I knew I would be spending money that would not be able to be reimbursed. So, the error on the side of caution would be to the benefit of those seeking a lottery license, because this is a very strong case. And they may want to step back and wait until they know which direction this case is going to head.
Is basically what you're asking for legally that they not move ahead with slots at the tracks unless the voters approve a constitutional amendment. Correct? Is that basically the bottom line of it?
The bottom line is, constitutionally, they're not allowed to have slot machines at the racetracks. So yes, if they want slots at the racetracks, go back to the ballot, ask the people, would you like to have slots at the racetracks? Don't assume. If that was always the case that they were allowed, why did they spend millions and millions in 2006 to try and get it passed? I mean, we're making some awful big, the governor's making some awful big assumptions and stretches here.
Do you believe the lottery overstepped when it began offering Keno?
I don't.
It's
Sorry.
a gray area that's not a part of our focus, but they walked up to the line with.
How is this any different? I mean, the lottery's going to say this is just another game. I mean,
in Keno, you know, I don't think that the voters intended in 1973 they would have a statewide game where numbers would be drawn every couple of minutes. No, without a doubt. In Keno, everyone in the state's playing the same game, correct? You're all watching numbers be drawn at the same time across the state. In a slot machine, you're sitting in front of an individual terminal that's playing an individual game. I mean, so as Melanie mentioned, they definitely walked up to the line. That is not part of this suit, but there is absolutely no doubt that the slots at the racetracks does not fit anywhere close to the amendment in 1973.
Another significant clue is that they had to pass a completely separate set of rules for the slot machines. The Keno was approved under 3770. They had to create a new category for the slot machines. And even in that set of rules, there is specific language that says that these are not instant games, which are the 3770 games.
Is this lawsuit going to require you to get, gaming laboratories to come in and do affidavits saying that this machine is, in fact, a slot machine, or are you going to need that kind of technical?
No, we'll just look at the Constitution the way it was amended in 1973. It's very short, very sweet, and very simple. And that's where we'll take a look. I don't think there'll be any need for anyone to come in and authorize anything.
Whatever happened was there a lawsuit last year or the year before, maybe the governor brought it, or somebody was trying to clarify this issue? Did that ring a bell? I mean, there was a suit somewhere. Did that just die? Or?
There were 3 suits filed, and we were actually one of them.
You mean in
2009.
In 2009 when Strickland authorized slots? Yeah.
Right. Because one of the suits dealt with the capacity to have a referendum on the statute. There was, I believe, a stay that was issued. Since the referendum didn't take place, and we were waiting to see what would happen with that as well, once the stay expired, the statute was able to go into effect. By then, there was discussion of other issues. We waited till we thought the time was most appropriate to refile our concerns and add to it what's been done since 2009.
One reason, your group is against gambling. I know you're also arguing you don't want to see the Constitution butchered and so forth. Okay, but I mean, one of your motivations, you don't want to see government in the gambling business or authorize it. Do you really think that there will be, now that we have casinos, to have slots at the tracks, does your group believe that there will be a lot more gambling with slots at the tracks? Won't there just be kind of cannibalizing here and about the same amount? Will there be that much more gambling with slots at the tracks?
2 things. Gambling and good government just don't mix. I think that's important to point out. There's no doubt about that. We've seen what's happened since 2009. Gambling and good government just don't mix. But in relation to that, just because we've put casinos in those 4 locations or authorized casinos in the 4 locations doesn't mean we should throw everything else to the wind and say, oh, it's all there. The important point is we're ignoring the amendment of 1973 to allow this to happen. I know that's not the answer you wanted to hear, Bill, and I'm sorry I keep harping on that, but it's about the rule of law and it's about the Constitution. And if we ignore that, just because the 2009 amendment did not trump what voters said in 1973, and it didn't alter it in any way. So for us to make the assumption of that, that's a stretch, and we could do that on a lot of different issues.
Follow up.
Okay.
In 2009, in House Bill 1, and again in House Bill 277, language was inserted to specifically exempt the lottery from Chapter 2915. That struck my nerve endings because what they were doing was exempting themselves of the entire criminal code dealing with gambling for the lottery. That means if the lottery is allowed to do slots, they can do craps tables, they can do poker, they can do whatever they want. If they're not going to be held to the boundaries of what the voters said, that's why on this issue, it's so important to understand that our focus is the rule of law. Because once you set aside the rule of law and the boundaries that were put in place by the citizens of Ohio, then the barn door's open, anything goes. And they've already indicated that's the direction they're going by exempting the entire chapter of 2915, not just the definitions of slots.
Because you say this should be a constitutional amendment. It can't be just a plain ballot issue to put those slots in there?
It could be either via joint resolution or initiative petition.
For the role of the state lottery, it would have to be a constitutional amendment. And that can be done in one of two ways, a citizen's petition or a joint resolution through the General Assembly. So there are processes to be followed if the lottery wants to operate slots at the racetracks.
And again, let's look back to 2006. If the authority was there in 2006, why would they spend all that money to go to the ballot to put slots in the track? Why haven't they done it before? And now all of a sudden it's being done and the deal's being negotiated as a quid pro quo when the track owners are the people who have the 4 casino licenses, and we will let you put slots in those, but you have to agree to pay this amount of money more. And by paying this amount of money more, we're going to pass a statute that says you don't have to pay the cat tax. I mean, it doesn't make any sense. I mean, is that what the voters intended? Is that what they intended in 2009? And again, look who wrote the language. The gambling industry wrote the language. If they didn't want to pay the commercial activities tax, why didn't they put it in there? They put everything else in there.
And just for clarification, they will be required to pay the tax, but what they've done is they've changed the framework of what that means for them.
Right.
The last time you raised this fundamental issue, that if they want to do this, they need to go change the Constitution, you got sidetracked by this referendum thing by the other group.
Yep.
Now, is there any possibility that could happen again, or that's structurally that couldn't happen again?
Well,
It's not likely.
I know there's a lot of cameras rolling, so it's not likely. And I don't think the people that did that before, I'm not saying I know who those people are, but I don't think they would be interested in doing it again. That's my opinion. So I don't see it happening.